Start. We are of the opinion that the agreement to pay on the basis of which the present petition is filed by the petitioner does not come under the definition of operational debt. On this point, order dated 14/5/2019 of the Nclt Allahabad in company petition RB number 343 Allahabad 2018 in the matter of Messrs. Delhi Control Devices Private Limited versus Messrs. Feeders Electric and Engineering Limited is relevant. Further unpaid installment as per the settlement agreement cannot be treated as operational debt as per section 5 clause 21 of IB code. The failure or breach of settlement agreement cannot be a ground to trigger CIRP against corporate debtor under the provision of IBC 2016, and remedy may be elsewhere, not necessarily before the adjudicating authority. In the light of the above decisions and provisions, we are of the view that the case of the petitioner is governed by the aforesaid decisions and the default in payment of installments according to agreement to pay in question entered into between the parties does not come within the definition of operational debt. Besides, there was pre-existing dispute on the issue of maintenance lifts between the parties, as seen from the email communications of the users of elevators. Simultaneously, parallel proceedings have been initiated for dishonor of checks under section 138 of the Negotiable Instruments Act. All the above prove that this tribunal has no jurisdiction to entertain this petition under section 9 of the IB Code 2016. We are therefore not inclined to admit the petition. We have heard both the counsel. The counsel for the petitioner submits that the amount that is due is towards the salary that is to be paid to the OC. Since the CD did not pay the salary I agreed, this application is filed. The respondent does not offer any argument and she submits that the order can be passed on merits. A perusal of the MOU would show that there was an agreement to pay rupees 18 lakhs as full and final settlement. It was also agreed that rupees 10 lakhs would be paid under first installment and remaining rupees 8 lakhs would be paid later, that is on or before 24th February 2018. It also shows that a check was issued with a post date for the said amount. It is also clearly rectified in the MOU that in case of non-compliance or deviation from any one of the agreed terms or non-payment of final installment, the entire claim of rupees 20,19,452 with interest by the first party shall stand good, and the first party will be entitled to proceed with all the pending cases or initiate any appropriate proceedings as may be required towards the recovery of the amount of rupees 20 lakhs 19,452. The judgment which is relied upon by the CD seems to have been rendered on a different set of facts, except the extract of the judgment which is reproduced above. The full text is not placed before us. What can be understood from the above extract is that the amount due under the agreement therein did not qualify for an operational debt. Hence, the same cannot be applied to the facts of the present case. Salaries fail within the definition of an operational debt under section 5 clause 21 IBC, as according to the said provision, a claim in respect of goods or services including employment is an operational debt. In view of the fact that the MOU is violated and that the amount under the MOU is due towards the salaries of the OC and that it was admittedly not paid, we do not find any reason to disallow the application. Accordingly, the instant application is hereby admitted and this adjudicating authority orders the commencement of the corporate insolvency resolution process, which shall ordinarily be completed within the timelines stipulated in the IB Code 2016 as amended. From the day of this order is passed, the operational creditor has not named anyone as interim resolution professional (IRP) and has requested this adjudicating authority to appoint one for the insolvency resolution professionals as IRP. The Insolvency and Bankruptcy Board of India (IBBI) has recommended a panel of insolvency professionals, 6 for appointment as insolvency resolution professional for the period from January 1, 2023 to June 30, 2023 in compliance with section 16 clause 3 clause A of the code in order to avoid delay. The IRP is directed to take charge of the respondent corporate debtors management immediately. He is also directed to cause public announcement as prescribed under section 15 of the IB Code 2016 within 3 days from the date of the copy of this order is received and call for submissions of claim in the manner as prescribed.